Hello everyone and welcome to this episode of Steve's Horse Show. This is one of the first episodes I've ever had that I'm not walking around, moving around, jumping around with a horse in the shot or something similar to that. This is a somewhat serious conversation about equine law. Mary Westman is with us and she is going to talk about collecting from somebody that has not been paid. And if you are in the horse business, there is all sorts of facets of people paying people after the fact and after the horse has been trained, after the product has been delivered and things like that. So introduce yourself and tell us about the article that you've written recently.
Thank you. Well, yes, my name's Mary Westman. I'm an attorney here in Oklahoma, and I recently wrote an article on Oklahoma stable keeper lien and foreclosure laws for the Oklahoma Horses magazine. It's actually in the January and February publication for 2022. And it's certainly an important topic. It's one that kind of intersects with both contract law and statutory lien law. I think that it's important to bring out the fact that both of those bodies of law are creatures of state law. So my comments today are going to be specific to Oklahoma law. That's where I practice. But if anyone is reviewing this, they need to understand that their state laws and jurisdictions are going to govern no matter whether it's a contract that is oral or written, or whether they are trying to assert some sort of statutory lien for services that they've provided.
So this conversation is specific to Oklahoma, but the mentioning article you did give a little bit. If you do have other questions, perhaps you could refer to that article. They do have a website with the magazine on that, and you can dig a little bit deeper into this topic because this is a very deep topic and a lot of nuances that can be involved with it. But a general overarching theme to get started, let's say, what are the good and bad things that people do? Let's start with the good things. What are some of the good things that people do in relation to not being able to collect from a client, whether that's a physical product or a service that you've provided or something similar to that? What would be some of the good things that people do that someone should stick to?
Well, first of all, being a horse industry participant myself, I'm grateful that there are those people out there willing to offer equine services, whether that's horse boarding or training or farrier services or whatever service that individual is providing. That is certainly something that benefits all of us who own horses. One of the other things that I would caution is that if you're going to put yourself out as a professional equine service provider, you need to reduce your services to writing. Oftentimes there are situations where individuals get into an arrearage and there is some dispute among the parties as to A, what services were you going to provide, and B, how much I was supposed to pay you, and C, how often. And unless there is something in writing that kind of clearly outlines what services you're going to provide and what expectations there are of the horse owner, it's going to cost money. It costs money to try to pursue legitimate services that you've provided.
So let me ask you this though, with that, and it's funny you call it a written agreement, right? But it's usually only brought up if there is a disagreement. And I've always thought that was weird. A written disagreement is what it feels like it should be called. But with a written agreement or a contract or whatever, if I'm watching this and I was listening to you, I'd be like, man, I can't afford, I'm not gonna go to the lengths of every time I want to train for somebody, I got to draw up a new contract and blah, blah, blah. Does it have to be something that's written, signed, notarized, written by an attorney and all that stuff? Or is it something as simple as a few bullet points?
Well, it's a contract, right? Okay. So I think that spending a little bit of money up front to put together a nice contract written for your specific state laws is money well spent, because spending a couple $100s to get a contract that you can use over and over, it's not necessarily something that you would have to recreate every time, right? Okay. you would customize it for the individual horse or the individual horse owner, but it certainly would not have to be redrafted every time. But trust me, it's going to be far more expensive if you're trying to collect than if you just go ahead and spend a little bit of time and a little bit of money and have that done correctly up front. I would caution about going to the internet and trying to cobble together your own, because remember, you might pull up a contract that's drafted on the laws of Virginia. And it might even reference the Commonwealth of Virginia. We're not a Commonwealth, we're a state.
Gotcha.
And remember, what you find online may or may not be applicable here in Oklahoma.
Gotcha. So especially around equine law, it's very state specific?
Yes, it's absolutely going to be state specific. Both contracts and statutory liens are creatures of state law.
Okay.
You know, they're going to be formed and interpreted under the laws of the state in which you provide your service. So it is going to be different every place you go. For example, in Oklahoma, relevant to our topic here, regarding liens and liens that you can assert for services or products that maybe you've provided on behalf of a horse owner, horse or training services are covered. That is not true in every state.
Gotcha.
So if you are a horse trainer, do not assume that the training services that you provide are necessarily services that you can recoup through a statutory lien. Now, that doesn't mean you can't recruit boarding, right? If you've boarded the horse and you've expended services in horse bedding and feed and hay and all that, that may be covered, but whether or not your service, the service of training a horse, is covered is going to be state specific.
Gotcha. Okay, so the burning question in probably every trainer's mind and every boarding facility's mind and anyone that has done a service with a horse that still retains the horse is, can I keep this horse in lieu of getting paid and maybe sell that horse or whatever? Is that a legal thing to do?
It is. One of the things I'd quickly, what are some of the things you can do? Obviously foreclosing on your lien is an option. It's so long as you follow the steps that you have to follow within the statute.
And a written contract makes that easier?
Written contract. You can provide for a lien in a contract, right? That's a contractual lien. You can also implement interest and late payments. My advice is to not let your clients get in arrears, because trust me, very quickly the amount they owe you is going to far exceed the amount and value of the horse you're holding and perhaps the equipment that you're holding. So get your service agreement in writing. Make sure that the horse owner understands their duties under the contract. Hold them accountable to those duties. Do not let them get in arrears. Take advantage of your ability to put in interest and penalties. That's meant to deter late payments, obviously.
Gotcha.
And then, you do have a right to foreclose under the laws of Oklahoma, but you need to be very cautious about following that law very closely, because if you foreclose on your lien and you have not followed the law, you can be liable to the horse owner. So my comments obviously are meant to be educational. It's certainly not giving legal advice to any individual. I think if someone is in a situation that they need legal advice, they need to seek that legal advice, because your legal advice is going to be different depending on your situation.
Yeah. Let me ask you one final question, and that's around products. A lot of people that deal with horses probably do a lot of secondhand tack and equipment, whether it's a trailer or maybe somebody in the feed business or something like that. What about products? Is that something that you can you take those back or hold them hostage in some sort of way?
Well, so what you're saying is if you have sold
let's say somebody sold a saddle or a trailer or something and they were going to pay them in installments or something like that. Is that something you can just go pick up, or?
Sure, because there's a law of replevin in Oklahoma. So it's again, there are very defined steps that you have to follow for it's considered to be a self-help statute.
Can't show up on their property.
You have to make sure that you're following the law, but the law is there to protect you. So, just like the bank can come in and repossess your vehicle, right? If you stop paying for that. Replevin law is akin to that, not specifically the same. But trust me, there are very specific things that you have to do before you just enter into somebody's property to recover something they haven't paid for.
Yeah.
Or that you allege they haven't paid for. Again, if it's not in writing, it's a he said, she said, and you do not want to get into that position. It's very expensive to pursue your rights when you have not put it in writing.
Gotcha.
So,
Yeah. So if
not
if you
impossible.
don't have a written contract, you're Mary's mad at you.
It's not impossible, but why make it more expensive for yourself?
Right. For something that's so easy too.
Right.
Yeah. Cool. Well, thank you for watching this show. If you have any questions, Mary is easy to find. You can look her up, Mary Westman, and she can help you out further if you have a very particular situation that you would like help with.